The tribunal room was formal and austere, its high ceilings amplifying every shuffle of paper and every clearing of a throat. At the front sat the Disciplinary Committee of the Health Professions Council of South Africa. Their task was to weigh evidence, not emotion. Yet everyone in the room sensed that this hearing was about more than a professional complaint. At the respondents' table sat Professor Tim Noakes, sports scientist, author, and once one of the strongest supporters of the high-carbohydrate approach to nutrition. Today, he was the accused. The charge was simple on paper: unprofessional conduct for advice given on Twitter. But the consequences for science and free expression were far more complex. The man before the tribunal. Before the proceedings began, the committee reviewed the background of the respondent. Professor Noakes had spent decades in academia. He had run more than 70 marathons, published widely, and built an international reputation in sports science. His research on endurance and fatigue had influenced athletes, coaches, and doctors around the world. For many years, he supported the high-carbohydrate diet that dominated sports nutrition. He even helped promote it. But later in life, after developing diabetes, he began to question those same guidelines. He turned to research on carbohydrate restriction and insulin resistance, eventually becoming a leading advocate for the low-carbohydrate, high-fat diet known as LCHF. His shift in position created controversy. Some colleagues praised his willingness to change his mind in light of new evidence. Others accused him of promoting unproven and potentially dangerous advice. It was within this tense professional atmosphere that the case began. The tweet. In February 2014, a breastfeeding mother posted a question on Twitter. She wanted to know whether following a low-carbohydrate diet would affect her baby, especially regarding foods like dairy and cauliflower. Professor Noakes replied publicly. He wrote that the baby would not eat those foods directly, but would receive healthy, high-fat breast milk. He added that the key would be to wean the child onto a low-carbohydrate diet. The tweet was brief and informal, but a dietitian saw it and filed a complaint with the HPCSA. She argued that he had given unconventional advice to a breastfeeding mother in a public forum. The council charged him with unprofessional conduct. Now, the hearing would decide whether that tweet crossed a professional line. Opening statements. Prosecution opening statement. The prosecutor stood, her voice steady. Members of the committee, this case is about responsibility. Professor Noakes is not an ordinary citizen. He is a medical professional with a large public following. When he speaks, people listen. She paused, then continued. In this case, he offered advice to a breastfeeding mother in a public forum. The advice was not aligned with established infant feeding guidelines. It was unconventional and potentially harmful. She held up a printed copy of the tweet. This was not a private discussion. It was a public statement, accessible to thousands. The HPCSA exists to protect the public. When a professional offers advice that may endanger health, it is our duty to act.
Members of the committee, this case is about responsibility. Professor Noakes is not an ordinary citizen. When he speaks, people listen. This was not a private discussion. It was a public statement, accessible to thousands.
She returned to her seat. Defense opening statement. The defense counsel rose calmly. Members of the committee, this case is not about negligence. It is not about a harmed patient. It is not about malpractice. He gestured toward Professor Noakes. My client did not diagnose, treat, or examine anyone. He responded to a general question on a public platform. There was no doctor-patient relationship. He paused to let the words settle. Scientists must be free to discuss evidence, even when it challenges conventional wisdom. If expressing a scientific opinion in public becomes misconduct, then scientific progress itself is at risk. He sat down. The room remained silent.
Members of the committee, this case is not about negligence or malpractice. My client did not diagnose or treat anyone. There was no doctor-patient relationship. Scientists must be free to discuss evidence, even when it challenges convention.
The evidence and testimony. Over the following months, witnesses took the stand. Dietitians testified about established breastfeeding guidelines. Experts debated the scientific evidence behind the LCHF diet. The prosecution emphasized the danger of public advice that contradicted accepted standards. They argued that Professor Noakes' status gave his words authority, and that such authority came with responsibility. The defense focused on the nature of the tweet. They argued it was a general comment, not a clinical consultation. They stressed that no doctor-patient relationship existed, and that the HPCSA's own rules required such a relationship for a misconduct charge. When Professor Noakes testified, he spoke without drama. "I gave what I believe to be evidence-based information," he said. "Science evolves. We must be able to discuss new ideas openly." Closing arguments. Prosecution closing argument. The prosecutor rose once more. "Members of the committee, the facts are clear." A breastfeeding mother asked a question. Professor Noakes, a registered medical professional, gave her advice. She held up the tweet again. This advice differed from established guidelines. It was given publicly to an audience of thousands. He used his professional authority to promote a controversial diet. She spoke slowly and firmly. The public trusts medical professionals. That trust must be protected. If doctors are allowed to give unconventional advice on social media without consequence, the result will be confusion and potential harm. She concluded, "This is not a trial of science. It is a matter of professional conduct. We ask that you find Professor Noakes guilty."
Members of the committee, the facts are clear. This advice differed from established guidelines and was given publicly. The public trusts medical professionals. That trust must be protected. We ask that you find Professor Noakes guilty.
Defense closing argument. The defense counsel stood for the final time. Members of the committee, this case has lasted years. Witnesses have debated science, nutrition, and public health. But the charge before you is simple: unprofessional conduct. He looked around the room. There was no consultation, no examination, no treatment, no patient. Without a doctor-patient relationship, there can be no professional misconduct. He paused. If a scientist cannot answer a question on a public platform without facing disciplinary action, then scientific discussion becomes dangerous. And when discussion becomes dangerous, progress stops. He turned toward the committee. This case is not only about Professor Noakes. It is about whether professionals are free to express scientific opinions in public.
Members of the committee, there was no consultation, no examination, no patient. Without a doctor-patient relationship, there can be no misconduct. This case is about whether professionals are free to express scientific opinions in public.
He sat down. The verdict. After deliberation, the committee delivered its decision.
This committee makes no credibility finding as far as any of the nutrition experts is concerned. And in terms of the case law relating to expert testimony, and quoted above, and on a totality of all the expert evidence presented before this committee, it cannot be said that testimony of the respondent and his witnesses do not also have a logical basis. The majority of this committee, being 4 of the 5 votes, find the following on the facts. 1. The pro forma complainant has not proven on a balance of probabilities that the respondent was acting in his capacity as a medical practitioner or in any dual or multiple capacity, which included the capacity of a medical practitioner, when he tweeted Ms. Leenstra on 5 February 2014. Secondly, on the probabilities, the respondent was acting as an author and proponent of the LCHF diet. 3. The pro forma complainant has not proven on a balance of probabilities that the respondent gave medical and or clinical and or medical nutritional advice and or medical nutrition therapy when he tweeted Ms. Leenstra on 5 February 2014. 4. On the probabilities, the respondent provided information to Ms. Leenstra as an author and proponent of the LCHF diet. At best, his response was ambiguous and not a direct response to a query. At worst, the response, without clarification, may be interpreted as confusing or unclear. To understand the response properly in the context of the LCHF diet, there would have had to have been meaningful dialogue between Ms. Lenstra and the respondent. It is common cause there simply was none. 5. The pro forma complainant has not proven the existence of a doctor-patient relationship on a balance of probabilities. 6. On the facts and probabilities, there was indeed no doctor-patient relationship. 7. The pro forma complainant has not proven on a balance of probabilities that the respondent contravened any law, regulation, or ethical rule. It has certainly not proven on a balance of probabilities a contravention of regulation R237 of 6 March 2009, in that this committee could not find on the facts that the respondent advised or diagnosed anyone or any baby on his or her physical health status. 8. The pro forma complainant has not proven on a balance of probabilities that the respondent gave unconventional advice or advice which is not evidence-based. 9. On the facts, this committee finds that no actual or potential harm was proven, neither that any information provided on Twitter by the respondent, whether unsolicited or not, was dangerous or life-threatening. 10. The pro forma complainant has thus not proven on a balance of probabilities that the respondent, as a medical practitioner, acted unprofessionally and in a manner that is not in accordance with the standards and norms of the medical profession. Professor Noakes, on a charge of unprofessional conduct, the majority of this committee find you not guilty.
HPCSA appealed the decision. The case continued for another year, but the appeal committee upheld the original verdict. Once again, he was found not guilty. Aftermath. As the tribunal room emptied, it became clear that the hearing had been about more than a single tweet. To some, it had placed the low-carbohydrate, high-fat diet on trial. To others, it had tested the authority of professional guidelines. And to many, it had become a symbol of the struggle for freedom of scientific expression. In the end, the tribunal cleared Professor Noakes. But the questions raised in that room about science, responsibility, and freedom continued long after the verdict was read. The trial had ended. The debate had not.